It is USAA's position that proper notice under 542A.003 was not given prior to the filing of the lawsuit. Now, 542A.003 of the Texas Insurance Code has very specific requirements. And let's see. The requirements are under 542A.003B, required, they must give a statement of the acts or omissions giving rise to the claim, the specific amount alleged to be owed by the insurer on the claim, and the amount of reasonable and necessary attorney's fees incurred by the claimant, calculated by multiplying the number of hours actually worked by the claimant's attorney as of the date the notice is given, and as reflected in contemporaneously kept time records by an hourly rate that is customary for the legal services. This notice must be given not later than 61 days before filing the lawsuit. And further, the attorney on behalf of the claimant shall provide a copy of the notice to the claimant and include in the notice a statement that a copy of the notice was provided to the claimant. Right, so those are all of the elements that must be in this very specific statutory notice. Here, it is USA's position that any notice that plaintiff attempted to give was defective and did not meet these requirements. And the statute actually allows two remedies to the insurance carrier. The insurance carrier can file a verified plea in abatement and seek abatement of the lawsuit, or alternatively, under 542A.007, I'll scroll down here. Sorry. Subparagraph D, if a defendant in an action to which this chapter applies pleads and proves defendant was entitled to or was not given a pre-suit notice stating the specific amount alleged to be owed by the insurer under section 542A.003 B2, at least 61 days before the action was filed by the claimant, the court may not award to the claimant any attorney's fees incurred after the date the defendant files the pleading with the court. A pleading under the subsection must be filed not later than the 30th day after the date defendant files an original answer. Here, USAA filed its verified denial of receipt of this notice on November 4th. Its original answer was filed, it's October 20th, so within 30 days. The plaintiff's lawsuit was actually filed September 11th, 2020. Actually, the original answer was filed December 10th, 2020. And this verified denial, the pleading specifically asserting their failure to provide the notice, was filed November 4th, 2020. Now, in this matter, by way of background, plaintiffs retained a public adjuster very quickly after the tornado struck Dallas. And that public adjuster dealt with USAA on behalf of the plaintiffs throughout the claim. In August of 2020, plaintiffs retained Ms. Bella's law firm. Now, as a procedural matter, Your Honor, I realized this morning that our exhibits were not attached to our motion. And so we filed an appendix this morning with those exhibits attached. Both exhibits A and C we had a copy delivered to the court, but in case the court doesn't have them there, this is exhibit A. And I would mention that Ms. Bella, when she filed a response on Friday afternoon, attached these documents as well. So this is the letter received from Ms. Bella's law firm. It's 14 pages, though part of it includes the original petition that was filed. Now, in this letter, while they set forth an amount that they are seeking to recover, they discuss policy provisions and they discuss some facts, which we dispute, but nonetheless, they discuss facts. But nowhere in this letter is there a demand for attorney's fees, or any of that paragraph requires a specific amount for attorney's fees. Further, this letter did not give 60 days or 61 days as required. Rather, it required a response within 14 days, from August 26, 2020 to September 10th, 2020. And another deficiency in this notice letter is, in fact, that nowhere does it reference that a copy was actually provided as required by the statute to the insured, to the plaintiffs. The letter itself, like I said, is about 6 pages and attached is plaintiff's original petition. 542A has been strictly construed. Now, I do concede that the majority of the cases that involve the statute have been on the federal level. But just recently, and in your notebook, we did provide you a copy of an opinion that just came down at the end of February of 2022 by Judge Brown out of the Northern District. The site is 2022 Westlaw 614995, Betty Rahe, R-A-H-E versus Meridian Security Insurance Company. In that case, defendant, as USA has done here, affirmatively pled in its answer the failure of the plaintiff to provide the 60-day pre-suit notice as set forth in the statute. And Your Honor, that case should be back at the very back of your notebook under tab 3. It's actually the last few pages. They're the last 3 pages under tab 3.
What I have does not have any tabs. I have the appendix, the defendant USA's General Indemnity Company. Use motion to dismiss attorney's fees pursuant to Texas Insurance Code. But there's no, I don't see.
There was also a notebook that was provided last week, Your Honor, last Thursday.
Let me go see if I can find it. All I had was this one. Give me 1 second.
All right.
I found the notebook. So tab 3.
Under tab 3, and actually there are 2 cases there, but it's the very last 3 pages in that notebook. It should be the Rahe, R-A-H-E versus Meridian Security Insurance Company case.
Yep, I see it.
All right. In that case, the plaintiff gave the notice, but didn't wait the 60 days before filing the lawsuit. Here we have the same. Well, I disagree that this notice provided by Ms. Bella comports with the statute. We know without question that they did not wait the 61 days as required by the statute before filing the lawsuit, a prerequisite to recovery of attorney's fees under this statute. The court specifically held that the plaintiff was required to wait 60 days prior to filing suit and that limitations on her attorney's fees are the appropriate remedy. As I mentioned, 542A007 provides us this remedy under Section D that a carrier has two options. They can file a verified plea and abatement if they'd like, or they can simply seek to strike recovery of attorney's fees. And that's what USAA has done here. Now, we anticipate, based upon the response that Ms. Bella filed, that she's going to attempt to argue, well, the public adjuster told them about some of this stuff, so therefore that should be sufficient to comply with the statute. But quite frankly, this statute doesn't particularly allow for anyone other than a lawyer to provide notice. And in fact, I think to do so, any other party would be the unauthorized practice of law. And the notice has these very specific requirements. Without question, this letter, Exhibit A, which you have there in the second notebook, Your Honor, there is no amount of reasonable and necessary fees incurred by a claimant. And there is also no indication that this notice was provided to the claimant, to the Crossmans. Based upon the plain language of the statute and what must occur before a lawsuit is filed to be able to recover attorney's fees under 542A, all of these boxes must be checked. And that's what the courts have and are consistently holding, is that on these motions to strike attorney's fees, the boxes must be checked. And here, quite frankly, they did not check the boxes. It is a strict liability statute, for lack of better words, in terms of what the notice must cover. USAA filed its verified denial, its verified pleading about the failure to give the notice on November 4th, 2020, and now seeks to prevent plaintiff from recovering any fees after the filing of that pleading on November 4th, 2020. Under plaintiff's argument, which we anticipate they'll be making, that, well, the public adjuster provided information. Quite frankly, Your Honor, if that were the case, 542A would never come into play, which is not what the legislature intended. And in fact, the legislature intended this very specific notice to try to promote settlement. As set forth, a demand which gives 14 days does not comply with the statute. A notice which does not set forth attorney's fees does not comply with the statute. A notice which does not indicate that it's actually been provided to the claimant does not comport with the statute. Therefore, because USA has pled and proven that it did not receive the statutorily required notice under 542A003, USA General Indemnity Company asks this court to enter an order striking any recovery of fees by plaintiffs after November 4th, incurred after November 4th, 2020.
So I'm looking at the other case, Daly versus Amgard. That seems to support the plaintiff's position in this case.
Well, no, Your Honor, I would actually disagree, because that case even did not, that notice letter actually provided some indication of what reasonable and necessary attorney's fees were. Here, there is nothing. There is no amount whatsoever set forth in this letter with respect to recovery of attorney's fees.
Okay.
It's got to give us an amount, and there's no amount given anywhere in this letter.
Ms. Bella, response?
Your Honor, the wrong letter is being focused on, and if I could share screen as well.
Let me.
I'll stop. Okay.
Okay, go ahead.
Let me see if I can actually do it. So the appropriate letter was a May 20th, 2020 letter that was sent by the public adjuster in this case. And he sends it to Mr. Jamie Fair at USAA. He's talking about, we've tried to work with you. And this is Exhibit B to our response. There is also an Exhibit A, which was sent earlier in the month, talking about how there are bad faith claims and we're trying to work with you. This was Exhibit B, May 20th, 2020. I shared you all of this information. We've been able to provide you supporting documentation, including a detailed FLIR thermal imaging report to support our findings of moisture penetration behind the drywall in nearly all the rooms. I shared that information with you on December 10th, 2019. So we're 5-6 months after they were providing that information. In addition, USA sent out a second engineering crew to re-inspect the loss, including the attic space, which was not inspected on December 2019 and after the March 2020 Hague inspection. Our licensed architect and general contractor were able to inspect the same attic locations and found over 4 times the rafter damage. They're going into, these are all of the details. This is why you need to pay this claim. We have engineering reports. We have architect and general contractor telling us this house, that the roof cannot be patched. It needs to be replaced. And he's laying this out in this letter on May 20th, 2020. I've supplied you the detailed engineering report on that damage, April 21, 2019. However, you nor anyone from USAA responded to the report. Finally, on May 4th, I sent a final email to you stating that the Crossmans were beyond frustrated and were considering hiring an attorney. I attached as Exhibit A to our response, Your Honor. I asked you to respond to me by May 15th with hopes we could work out the difference. Since I've not received a reply, we're filing this notarized proof of loss of coverages for A and B, and they attached their sworn proof of loss, and it has the total amount. The full cost of repair or replacement is $634,681.48. All the statute requires is that you lay out the statement of acts or omission. That letter goes through the acts or omission. It goes through a timeline of all of the issues and a specific amount alleged to be owed for damage to the covered property. That is the sworn statement and proof of loss in the amount of $634,681.48. Those are the 2 requirements. He says in his letter that they haven't hired an attorney yet. They hadn't hired me yet. So there aren't any attorney's fees if you haven't hired an attorney yet. I don't know how to do that. It says they're beyond frustrated and we're considering hiring an attorney. They specifically address the attorney issue, but there of course aren't any attorney's fees if there's no attorney. The statute does not require that this be sent by an attorney. That would mean that no pro se could ever abide by 42A.007. What the statute says is if an attorney or other representative gives notice. This was sent via email and CC to Barry Crossman, my client, so it was very clear that that notice was provided. The response we got from USAA, or my clients got, they got a response on May 21st that USA didn't agree with the architect report the day after that notice went out. Then they got another response on July 28th, responding that they don't agree with that demand letter. And that was 67 days after they sent that. 67 days later, USA responded, we don't agree with your demand. Then the Crossmans got me and they said, what do we do? And we gave one final, hey, let's give it another shot. The 542A.003 notice had already been provided, but I gave it one more shot. And that is the letter that USAA is focusing on today. So we'll send them one more letter. Maybe we'll do it now. This was not our 542A.003 letter. This is just a, hey, USAA, here's your one final shot. Here's all the law on it. And here's the petition. This is another attempt to resolve this pre-suit, but it is not the letter. The letter was sent months earlier. And in fact, even at the end of this letter that was sent August 26th, we say, demand for payment, you owe the Crossmans this amount as submitted in the sworn statement of proof of loss on May 20th, 2020. So we are again referring back to this May 20th letter. That May 20th letter complies with the standard. I don't know what additional information was needed by USAA. The whole point, the legislative intent behind this was to make sure that insurance companies are not surprised. And there is no surprise here. For many months, my clients attempted to resolve this. They attempted to do it without lawyers. They did not want to file a lawsuit, but their house was catastrophically destroyed in the tornado, and they had a lease coming up in 2 months, and so they're trying to get something done. And so all notice was required on September 8th. Before we filed suit, we got a response from USAA saying, we don't agree with your demand from your August 26th letter. So USAA even responded to this letter. And then a few days later, the Crossmans filed suit. That was 4 months after the May 20th letter that complies with 542A.003. So, Your Honor, we complied. I'm not sure how more clearly we could have complied. There was no attorney, so there can't be any attorney's fees. And all the other elements are very clearly met.
Sanjay?
Yes, Your Honor. On Exhibit B, which the May 20th, 2020 letter May 20, 2020 letter. That letter actually does not comply with the statute either. There is also no indication on that letter that it was conveyed to the claimant. It's made by a public adjuster. And again, I would urge this court that, quite frankly, there are articles out there that a demand by a public adjuster is actually under 542A is the unauthorized practice of law. I would also further note that the demand letter, which I've shown you as our Exhibit A, and plaintiff's counsel, I don't remember which exhibit was for her, but that demand letter actually demands something different and more than even what was put forth in this May 20, 2020 letter. In fact, not only do they demand $628,601 without any reference whatsoever to the almost $300,000 that had already been paid the plaintiff at this point in time, but also they ask for an extension of time on the loss of use for 24 months and ask for additional benefits under the policy. In the file and in the documentation you have, Your Honor, I need to share my screen if I could for a second.
Okay.
Exhibit 3, or Exhibit C, pardon me, which Ms. Bella mentioned, is we remained open. The loss of use coverage will be addressed according to the policy language and limits enforced at the time of loss. So, quite frankly, they did not allow even the 61 days as required by the statute to discuss the settlement, to make an offer of settlement, which the whole purpose of these statutes was also to attempt to facilitate settlement. As I noted, and unfortunately, because I didn't actually review Ms. Bella's response to this morning, I did take Friday off. But quite frankly, there's a whole lot about the claims handling, but this completely negates or refuses to reference all of the payments that were made to the plaintiffs during the course of this all. And in fact, yes, while there's a difference of opinion on what's the appropriate scope of repair, which arguably is part of the breach of contract claim, this demand, actually none of the documentation put forth by plaintiff meets the specific requirements as set forth by the statute. And so we would urge the court to grant our motion to strike attorney's fees and to strike any attorney's fees incurred after November 4th, 2020.
Ms. Bella, do you have anything else?
Briefly, Your Honor. First of all, the statute only requires that the damages are in the 542A.003 letter are the damages to the covered property. That's what's supposed to be in there by the statute. So it doesn't require that the parties detail damages from a bad faith claim, amounts that, that's impossible to detail, or any of that. It's just the damage to the covered property itself. And that's what was done in that letter. Your Honor, there is a cover page to my Exhibit B that looks like it didn't come on there. It didn't, for some reason, when we filed this, I don't have it on there. But the covered page shows that my client was CC'd on the email specifically to USAA. And so I would like to supplement that with that if the court will allow it. Because that very clearly shows that my client was CC'd and USAA had knowledge that they were CC'd, and it's the notice required for that document.
So, Ms. Sanji, is one of your arguments that they didn't detail the amount of the attorney's fees? Is that part of your argument?
Yes, Your Honor. It's required by the statute.
Okay, and then your response to that, Ms. Bella, is that there was no attorney involved at the time?
Yes, it says if an attorney. The statute says if an attorney or other representative gives the notice, then you have to give the attorney's fees down and see if an attorney or other representative gives the notice.
All right, I just pulled the statute back up for you, Your Honor. I can stop sharing if you'd like.
No, that's okay. But at the time you sent your letter, you were an attorney in the case. I guess why wasn't there an amount of attorney's fees at that point?
Well, we weren't trying to comply with 542.003A. That wasn't a 542.003A attempt letter. We believed it had already been complied with months earlier by that May 20th letter. I will say also, I didn't charge the Crossmans any attorney's fees for many months, so there weren't any attorney's fees at the time I sent that letter. But be that as it may, that August letter is not one that we are trying to rely on this case for complying with 542.03A. When my firm was retained, we believe that notice had already been appropriately given months earlier.
Okay, so my inclination is to kind of grant this in part and deny it in part. I think that any attempt to attain attorney's fees prior to the filing of suit should probably be granted. I mean, that there was never any indication that any attorney's fees have been incurred. But for attorney's fees after the filing of suit, it would seem like attorney's fees would be permissible, given that the original notice letter was filed before an attorney was involved. And Ms. Sandra, you say there's some letters or
Sure.
something that say that in a public adjuster, is there any case law that says a public adjuster can't send a demand letter?
Unfortunately, Your Honor, as old as the statute may now be, 5 years, there is not as much case law as we'd like on the subject. But what I'd like to do, Your Honor, if I could, just give me, if I could have 2 days, because we're almost at the end of the day here, to submit just a very short supplemental reply brief to her response directly addressing this public adjuster issue.
Why don't we do this? Now, first off, let me ask you this. You have a May 17th trial setting. Do you think that's a realistic date for y'all, or you guys going to be?
I don't think so, Your Honor. Ms. Bella's already reached out to me about a continuance. I've just not had an opportunity to discuss it with my client.
We do have a couple of depositions that need to place, Your Honor, and I have a setting in the 101st of May 3rd that's probably going to go. It's a 5-year-old case, jury trial, and it's going to last over a week. So trying to get those depositions in with that jury trial, it's becoming a challenge. So I'm waiting for Ms. Shanji. I know it's been over the holiday weeks if she's trying to get with her client, but I suspect we're going to have an agreed motion for continuance coming your way shortly.
So what I would suggest we do, there's a variety of reasons I want to do this, but we don't have to go into them, is give me this reply brief, Ms. Sanji. If you could get me a binder that contains all of the briefing for both sides, including because right now you're just giving me binders kind of piecemeal. You could put one briefing that includes all the binder that includes all the briefing, including the cases cited on both sides in it as well, with this reply brief. Obviously, he filed the reply brief as well. And then send that to Rhonda, my court coordinator, put on it urgent for judge to look at, and I'll take a look at it. But my thoughts is I probably want about a month to take a look at this after you get that to me. And so ideally, I would like to kind of continue this case, although it's not, if you guys can't reach an agreement, that's okay too. We can try it on May 17th. And then it would take about a month after I get everything from you, Ms. Sanji, to make a decision. If that doesn't work, then I'll try to make a decision more quickly. But then we kind of keep you to that May 17th trial setting.
Your Honor, I don't think that continuance is going to be an issue. Again, Ms. Bell is correct. She'd reach out to me last week, and just with the holidays, it's been difficult to touch base with the right people.
Okay, so give me the briefing, get it to me sometime next week or whenever you can, with all the briefing on both sides and all the cases cited and the statute cited as well in the brief book. And I'll try to get you a decision with the month. I'm happy to move the case. I don't know how many 2020 cases. Pretty much we're just trying 2018 and 2019 cases right now, and 2017 cases. Because of COVID, we're way behind. So the likelihood you're getting reached is low, but not impossible. So you might want to continue it to next year, but if you don't want to continue it that far, that's okay too.
Thank you, Your Honor.
Thank you, Your Honor.
All right, guys, anything else?
That's all.
I believe so.
Thank you, guys. You have a good day.
Thanks, you too.
Okay, is everyone here on the Lubinstein versus Richmond case?
Yes, Your Honor.
Yes.
Your Honor, this is Michael Tobolowski. Sorry, I accidentally muted myself. The reason my video is not up is I came down with food poisoning last night, and so I'm at home struggling a bit. I reached out to opposing counsel about trying to move this hearing, and I think they were under the impression there's an issue with the court's plenary power, and so that they needed to go forward for that reason. And so I'm here to push forward if I need to for that. Otherwise, I was going to ask the court if we can reset it, because I do think there's still more time.
Ms. Barger, how much time do you have?
If somebody could remind me when the judgment was signed, I think we were, when we moved this from the 15th to the 18th, I knew we were cutting close.
The judgment was signed February 11th.
So you have approximately 30 days after the motion for new trial is overruled by operation of law, Your Honor, for plenary power, as you know.
Yeah, so it's like,
So 75 days from February 11th is what date? I guess I have to do that in my, hold on. 75 days.
so that's gonna be about April 26th or so, approximately.
April 27th.
Oh,
April 27th. So you do have plenary power
another 30 days after that, right?
30 days after the motion for new trial is overruled by operation of law. That's correct.
It's
So
up to you guys.
I may have miscalculated that. So if Your Honor feels that he wants to move it, maybe we can move it to next week, since you'd still be within the 75 days even next week.
I'm happy to move it to next Monday if that helps, Mr. Tobolowski.
Anything helps, Your Honor, but I do want to stress, as difficult as it may be, I'm willing to try to power through if that's what the court would prefer. But Monday of next week, I have literally nothing on my calendar that would work, whatever the court would like.
Does that work for you guys?
I have a hearing at 11 o'clock in Houston, but if it's not at that time, I can do it.
Ken, does that work for you?
I'm just checking here. Yes. Yeah, that's fine. I've got something on that Tuesday, but I'm free on Monday.
How about Monday at 3 o'clock?
That would work.
That works. Thank you, Your Honor.
Mr. Tobolowski, I hope you feel better. We'll reset this to next Monday at 3 o'clock. You guys have a great rest of your day, okay?
Okay,
Thank you.
thank you.
Thank you, Your Honor.
All right, the asbestos lawyers, we have a brief, we have a slight, how to put this, logistics issue I wanted to chat with you about. Are you guys there, the asbestos lawyers?
Yes. Welcome for the plaintiff is here. We're here, Judge.
So this is our logistics issue, and I'm not sure what to do about it. There's no great solution. So I don't know how many of you guys have been in the courthouses here at the George Allen. My courthouse can fit not well, but 55 jurors if we use the jury box for jury selection. The Merrill Hartman can fit well over 100, so that's not a problem. But the problem we have is that the Merrill Hartman courtroom, we can get it on Monday. The problem is we can't get it on Tuesday because the Court of Appeals is using it that day. And so I'm not sure what to do. We could try to, what one option would be, we could, again, there's no perfect solution here, so I'm open to suggestions, is we could do the questionnaires on Monday in the Merrill Hartman, and then on Tuesday, we could do, we could take the first 55 jurors that show up that haven't been excused and try to pick the jury that way, or we could start with hardships and do those and then do the, it's just, I can't fit everybody in here. I mean, do you see what the issue is? But we could kind of go out of order, maybe do the hardships and get down to 55. Or we can delay the trial, or we could see about doing Monday and Wednesday maybe, which isn't ideal. or we could go with less jurors. I mean, I'm not, there's no great solution here. We only have certain facilities. Actually, I thought of one other thing that's not perfect. Let me call Judge Moore, but I thought of one other thing that might work. Let me see if she's available.
Frank, is this part of your master plan to get out of a meet and confer today?
How did you guess?
I don't know. You're the pup. You got this figured out.
Yeah, well,
You're on the office going, watch this. I'm going to get out of this meet and confer one way or another.
well, when was it? Thursday, when all the pretrial stuff was, we had an evacuation for our building. So I suspected you all had called something in. The old, I've got an exam today. Let me call in the bomb threat. The sad part about that was the next day my legs were really sore. I wasn't winded from walking down again, 34 flights of stairs. My legs were sore like I'd been skiing though.
Just on this juror issue, it strikes me that if we get the 100 into the bigger courtroom, you could hardship them and get the group down.
Yeah, that would make me feel better. I think that would give us a better shot, certainly.
It sounds like it might be more of a timing issue, though, with Judge Hoffman not having available time to hardship the whole panel on Monday. That was the impression I got earlier.
Right.
Yeah, or if it's not, 100 on Monday, if it's 75 or 80, would that make it a little more workable? I don't know. But we've got to have the courtroom space, I guess, regardless.
Mm-hmm.
About to email something over on the jury questionnaire. Catherine, do you just want me to go to you, or do you want to send it to all of you all, or what? Do you care?
You can send it to everybody. It's fine.
Okay.
Did you redline it, Frank?
No, sorry. I've just added a bunch of stuff since you had your wish list. I'm sending you mine.
Hello, Frank.
Sorry. Yeah, I'm on a Zoom conference court call. Thank you. So we may have to.
Did you use mine as a basis, or is this just like a whole new document?
No, I went through and made sure there wasn't something duplicative of what you had included.
Okay.
I've got another document that has a lot of the similar stuff, worded maybe slightly differently, but I'm fine with yours on most of it. I've just got some additional questions that are not on yours. And then I've got issues we could talk about with a few of yours.
Okay.
And
Okay, Judge, let me merge it. Hold on.
Guys, can you hear me okay? This is Judge Hoffman.
Hold on, Judge. Let me merge it in.
That's okay. I'm just talking to the attorneys.
Oh, I'm sorry.
yeah, yes, Your Honor.
Can you guys hear me okay?
Yes.
Yes.
Can you guys hear me okay?
Yep.
Yeah.
So I think I've figured out a solution. It's not ideal, but I think it'll work.
Sorry. Sorry.
Maureen voting no is not available.
Okay, Ruby, I think we worked it out.
Finish. Hang up or press pound for more options.
Ruby, are you there?
Okay, Judge. I'm sorry, I couldn't connect her. She must have got a call between them, I thought. Okay, we ready, Judge.
So I talked to Judge Moore and she's agreed to let me have 6D on Monday. So we're gonna need 6D on Monday and Tuesday next week because we're doing a 2-day jury selection. And then she's gonna take the Merrill Hartman instead
On the 25th?
on Monday, yeah.
Okay.
If there's any issues, let us know.
Okay, so what me and Laurie was trying to do, we just looked at the calendar, so we was trying to get you some dates. We got, you was gonna have the 25th in the America, and then we was gonna put you on the 28th and 29th.
Yeah, we only need it on Monday and Tuesday. We don't need any of the days.
Oh,
So we
okay.
just need it Monday and Tuesday. So we're gonna do 6D on Monday and Tuesday, and then Judge Moore is gonna do the Merrill Hartman on Monday
Okay, sir. So just the 25th and 26th, you're gonna take that?
for 6D, yes.
Okay.
All right, I
And we'll
think
switch her out, okay.
we're just gonna switch around. You can just confirm with Judge Moore, but yeah, I just talked to her.
Okay, we'll send Ms. Rhonda the reconfirmation.
All right, thank you so much.
You're welcome, sir. Bye-bye.
Thanks, Ruby. Bye.
Yes, ma'am. Bye-bye.
Guys, can you hear me okay?
Yes.
Yes.
All right, so we just worked it out. We're gonna be putting you in 6D, which is not the Merrill Hartman, it's on the 6th floor. Have you guys ever picked a jury there?
No,
We should be able to get 100 jurors. You're not gonna have a lot of room for attorneys. So I wouldn't bring a big crew with you because it's just limited space in the well. But we'll do jury selection Monday and Tuesday, just like we talked about, but we're gonna do it in 6D instead of the Merrill Hartman.
all right. That sounds great, Judge. Just for clarification, not that we're planning a big presentation, but is there a screen or something, a plug and play there or not? Okay.
I don't think I'll go check, but I don't think there's anything there. It's silly courtroom. So for Tuesday, did you have you're not going to do anything except for jury selection in that courtroom, but
Right.
are you doing a PowerPoint for jury selection?
Perhaps a few things, but it's not essential.
Can you call George real quick and see if we can, let me talk to our AV guy and see what's in there currently. They may have changed that I'm not super up. I haven't used Merrill Hartman since COVID, used 6D since COVID.
Your call has been forwarded to an automatic voice.
We'll try to find out.
4502.
I think there's a screen there. I don't know that there's regular AV equipment, but we'll check and we'll let you know, okay?
Thank you very much, Judge. We appreciate it.
Thanks, Judge.
6D, and hopefully, sorry to keep bugging you guys, and good luck with everything, okay?
Thanks.
Thank you, Your Honor, very much.